All right. So in the Google Drive, we have a thing in there with like real estate investment terms, and I just copied some information about deeds onto it, so it's there for you guys to check out. So as we've seen with Shane, not Shane, gosh, the core pepper trail, there's an issue with the deed. And so what is the deed? And so we're going to get into that a little bit. So one of the things in the county or wherever you're at that holds the information of deeds is called the Registry of Deeds. The oldest one in the country is in my neck of the woods in Plymouth, Massachusetts. The Registry of Deeds, it's super long because it's super old. And so when you go back and look on the county clerk for the deed, right, you're going to go back. It's something called the sovereignty of the soil. And so that goes back until the county or the state or wherever you're in or the country you're in was actually incorporated. So anything before that, it's called the sovereignty of the soil, for lack of a better word. And so what we need to do is when we put a property under contract before we close, is the title company is going to do something called an abstract of title. And what that is they're basically going to look preliminarily at the address at that particular piece of real estate, and to see the chain of title, who's had it, and has the deed been transferred properly, and if so, if it has been, then we're good to go, and there's not going to be any encumbrances or liens against it, and that means the title is marketable, that it's a marketable deed, and they will insure it. So basically, a title company. We use title companies here in Texas. Some other states use attorneys, but what they really are insurance companies, and they handle transactions, yes, and they make money off of the transaction. But they make most of their businesses writing insurance policies for titles. So the title company, like, we could technically sell the house by going around the title company for Pepper Trail, right? But if I'm a buyer, I would never want to do that. So, like, technically, like, Christina Corbin could give the dude a quit claim deed, and he could just take title by himself and start taking over the mortgage and go and record it publicly. But to me, that's hyper risky, and we'll get into why. So title companies, during a transaction, they're going to do the abstract of title, and they're going to go look at the chain of title all the way back to the sovereignty of the soil to ensure that the title is marketable and it's clean. And if they, in their search, they find that it is, they'll give you a title commitment, right? So Daniel, on your house, you would have had a title commitment. We're going to get a title commitment on every transaction saying that the title's good. If during their search something comes up, like Pepper Trail, then they'll let us know, and then it's our job it's mostly on us to rectify the problem. So, and I'll give you an example. So when I bought my house in San Antonio, the title company I used was called Preserve Title, and I didn't know who they were. It doesn't really matter. But the listing agent preferred them, I didn't really care. And they did their title search with a company called Chicago Title. Chicago Title's huge. And so Chicago did the abstract, and they gave the title commitment, which my title company, the closing title company, endorsed, and they gave the insurance policy. Now, when I went to refinance my house to bring my rate down, when I moved to this house, the title company, which was McKnight Title, that's actually a pretty good title company, right? That's local. There's a couple in San Antonio. There's one in Austin. There's one in New Braunfels too. There's one probably 10 minutes up the street from my house. That's where I signed docs for this house. My refinance. So we went to McKnight, and during their title search, they found an encumbrance on the title that the previous title company did not. And so what happened, and what it was that the previous owner had defaulted on his taxes, and to the point where, like, the city or the county, actually the county, opened up a lawsuit to begin the process of foreclosing for the taxes. And when you do so, but he paid the taxes, but that incurred a legal fee with an attorney. and the attorney didn't get paid, and it was like $900. But that was on the chain of title. And so basically what I had to do is go back to the previous title company and say, hey, you guys missed this. I need you guys to give an indemnification, sign an indemnification waiver to the new title company that's refinancing this, saying that if anything happens to come on this, you guys are responsible for missing it. Does that make sense? So like if the attorney wanted to come and say, I want my $900, well, he technically could, because he's got the equitable, he's got the interest in the title. Then that previous title company who missed that would have to pay him off, not me as the owner of the property. You follow me? So why is this a big deal? So in Shane's, God, why do I keep calling him Shane? His name is not Shane. In Corbin's case, Pepper Trail, let's say this dude Jason, that's not really interested in cooperating, vocalizes that he doesn't want the property. But let's say he gets into financial trouble and he gets in a bender and we buy it from him and we own it now. And he comes and says, hey, I have, like, this should be my house. I'm an heir. And you guys never talked to me about this. Well, if that didn't happen, well, he's actually right. He actually could sue us for that house and he would win, because that's how the probate system works in Texas. That's how it's going to work pretty much everywhere. It's pretty standard. And let's say we didn't have title insurance. Well, dude, we would be out all of the money we put into that property. Like, and there's nothing we can do about it. We would lose all of our investment, and he would get the property as is. Now, if we had title insurance on it and a title policy on it, and the title company happened to miss this, now it's their problem that they would have to go and make him whole and give him whatever interest and like monetary valuation that they agree to. That's the insurance. That's how the insurance policy works. You're muted, dude. Correct. That's why we have to do it through a title company, because it's going to save the buyer's ASS pretty much. Yeah, it's a huge risk mitigator. Exactly. And so that's why we have to have a clear and marketable title. So on the retail side of this, if we were going to if we took a title that was not good and we tried to flip it or remodel it and relist it, like the lender, whoever's going to like loan on that property, would not be willing to put their money into that unless it was a marketable title, for that reason, because it puts their investment at risk. It basically like jeopardizes the collateral significantly. You follow me? And let me know if something's not making sense. So let's take it from the top. So the deed is the legal document that transfers ownership of real property. Now, real property, so like let's look at it this way. So real estate legitimately just means the land, right? But it becomes real property when we improve the land. So real estate technically is like the whole thing, but the real property consists of the land and the whatever improvements are built on it, like a house, septic, a well, a gazebo, a racetrack, gardens, farm, cultivated soil, all that stuff becomes pretty much real property. Okay? Follow me? And so let's say you want to sell your house to me and I'm interested in buying it. What you're going to do is grant me a deed promising me that the title's clear. And you're going to do that because the title company is going to run an abstract of title and make sure that that it is clear. That makes sense? And so really the title insurance policy is on the benefit of both the buyer and the seller, because if you give me a bad title and you say it's good, I can come and sue you now. And we live in a place where people sue each other for the dumbest of things. Okay? So as we get into this, the language matters, nouns matter. So we have a grantor, which would be the sellor. All right, and a grantee, which is the receiving of the property. So the grantor gives the property, the grantee receives. So when you're going to look at on the county clerk website and we're looking at who's on the deed and what's going on here, they're going to use this language. Okay. Now, what gets confusing a little bit is when you have a deed of trust. So the deed of trust, so the deed is basically the legal document that goes on public record that shows who actually owns the property. Now, a lot of people will say when you have a mortgage, you don't really own the property. The bank does, but that's not entirely true. That's actually not true because according to the city, like the bank doesn't go on the deed. You go on the buyer goes in, the borrower goes in the deed. And so like you're the one that has total control and anonymity over what you want to do with that property, whether you want to renovate it, paint it, sell it, whatever you want to do. That's totally on you. Now, the lender secures their investment with collateral in a security instrument, which because you're gonna, and I'm using these words because if you go and look at this stuff online, you're gonna find it. So like looking at all these trustee sales on the mortgage, on the foreclosure list, they're using this language. And so because I know what these language means, I know what I'm looking for, I know who to find, I know what I'm looking, you know what I'm saying? And I get all the mechanics here. So so on the deed, follow me here, this is important to get on the deed that communicates the actual owner of the property. The grantor is the seller, the grantee is the buyer, the giver and the receiver. Now, on the deed of trust, it's inversed. So the borrower is the grantee. Oh, on the deed of trust, the borrower is the grantor. And they're the grantor because they're giving they're pledging the house, the property as collateral. And the lender is the grantee. They're receiving the collateral as a pledge. Does that make sense? You sure you follow me here? So the grantor is a giver, a grantee is a receiver. Okay? Yeah. Yeah. So like in our assignment contract, right? If we have the contract, we're the assignor. The one buying the property, the end buyer is the assignee. This is pretty much common legal law language, especially in real estate law, contract law. The grantor is the giver. The grantee is the receive. Receive. Okay. So in the deed of trust, the security instrument, the grantor is the borrower. The grantee is the lender, because they're pledging, the borrower is giving collateral. They're pledging the house as the collateral to secure the lender's investment, their money. And you're promising to pay them back. Follow me here? So the deed does not guarantee value. It just conveys ownership, interest in whatever the grantor has. So that could be just a piece of land. That could be a land with improvements. But it's pertaining to real estate. Whoever owns the land, and that's all it is. And so the kind of deed, this is where we're going to get into the weeds a little bit because this is going to matter. So I'm talking to you about going to this dude and having his wife sign a quitclaim deed, right? That's not the same kind of deed that we would get going to it, buying a retail, like I got with my house. I got a warranty deed with my house, which is the best kind of deed you can get. It offers the most protection. A quitclaim deed offers no protection, but it's public and it gets filed so that we know that this party has relinquished interest in the property, and so she has nothing to stand on. Later, if she was like, "Oh, well, I want money from this," well, she's like, "Well, too bad, you already signed this over, so you have no rights." That makes sense, and we'll get to that. So the kind of deed is basically going to determine how much protection the grantee or the receiver of the property receives. Okay. So the deeds differ based on how many promises or warranties that the seller makes about the property's title. So the best one we can get is a general warranty deed, and it offers the highest level of protection to a buyer. And so the grantor or the seller promises that they legally own the property. The title is clear of all defects, past or present, that no one else has any claims or liens unless they're disclosed. right? And that the title is going to be forever defended against problems that occurred before that they owned it. So if I sell you my house and I know that my title's clear, I'm going to guarantee that up until you take title from me, the title's totally good, man. No one's going to be able to come and get it, and that title insurance policy is going to be legit. Now, if you go and cloud the title by maybe not paying somebody or getting a child support judgment against you, like, well, that's on you. I up until I've given the property to you, I'm giving you a clear title that's marketable without encumbrances. That's what a warranty deed is. So in this kind of deed is using traditional retail sales, and the buyer gets maximum legal protection, and it's very common in owner occupied residential transactions. Now we're doing foreclosure stuff when we've got loan modifications, we've got other different things happening on here. So we have a probate situation here. So these muddy the water a little bit. And so typically they have to go through the court process to get the title cleared so that it becomes marketable again. So think about it this way, like a warranty deed is a guarantee that the property has no problems ever, pretty much. Now, a special warranty deed has limited protection or partial protection. Uh, and so typically what happens is that they can guarantee that there's no title problems whatsoever that happen while they own the property, but they cannot promise anything about that before their ownership. And there's certain situations where this can happen. Like I personally would be comfortable doing this because I just don't know. The only thing would be is the title search, like because like for example, like an attorney or a title company doing a title search is going to be a little bit more meticulous and in depth than we can do on the county clerk's website. Because they're looking at more than just the chain of title. They're looking at the people involved too, who owned it, like any claims that they might have had against them. This is why this is so arduous with Corbin, because um, in the event that anybody who's a rightful heir to this has any encumbrances on them, that's going to be paid out at the closing, that's another situation that, agree with it or not, it is what it is. That's a possibility. It's gonna have to. It's going to depend on if the title company is willing to insure because he's probably going to get a special warranty deed. The buyer's got to be cool with that too. So if we can get all of those people to sign a quit claim deed, and the title company's cool with giving a commitment to the title with that, then we should be good to go. Mhm. Yeah. Does this make sense? You following me here? So you have the warranty deed, no problems ever. The special warranty deed, no problems. Well, I've had it, but I just can't give you the guarantee before that. So as a seller, I would want to sell it this way. As a buyer, I'd want to buy it this way. You know, this is very common in commercial real estate. So like, for example, the last flip house we had was Larchmont, and we bought this with a special warranty deed, and it was an REO, which means the previous sellers actually the previous flippers gave this back to the lender with something called a deed in lieu of foreclosure, and we can talk a little bit about that too. So so basically it's like saying I didn't mess up the title. I guarantee that I didn't mess up the title, but I cannot account for anybody that came before me. So a grant deed, I don't believe we use these in Texas, so I'm actually not even going to cover this. See, a quit claim deed right here. This can be pretty good, but as a buyer, this can be a little bit, it depends on the situation, a little bit concerning. So a quitclaim deed transfers whatever interest the grantor has, if there's any, and it promises nothing. There's no warranties, right? So basically, like in the situation with Pablo and his wife, or whoever that lady is, if she's on the title and she genuinely is willing to just walk away, she could sign a quitclaim deed to her husband and have that filed and recorded, and that just removes her claim. Any interest that she had in it, that takes it out. That's why I think this probably could work for Corbin. I don't know why it wouldn't. So it's common between family members. Woo! Divorce settlements, clearing title issues, and transferring property into or out of an LLC or trust. So, like my house, if I sell my house on a wrap, I would probably want to put it into. I'd have it go into a trust for the people that bought it, and I would just have the trust set up where I would get beneficial interest if there was an uncured default. Do you understand what a default is? Okay. So like in law language, you have something called a cure period. And so if the cure, so like, and that basically means just like once the default has happened and it's been recognized and it's been notified of the borrower that they're in default, they have X amount of days, whatever the deed of trust is going to say, to cure it or make it right or rectify it or reinstate it, however you want to use it. They're all the same thing. If the cure period is not satisfied, then the lender will proceed to the foreclosure process to get their money back, to get the collateral to then get their money back. Following? Okay. So a quitclaim deed does not mean that the grantor has no ownership. It only means that they make no guarantees. So if I own anything here, you get it, but I'm not promising that I do. A simple way to teach it is if I own anything here, you get it, like Pablo and his wife, but I'm not promising that I get it. A quitclaim deed. Yeah. So the next one we have is a bargain and sale deed. Okay, minimal protection, and it implies ownership but offers no warranties. So we just don't know how the title is, and this is kind of risky. So the grantor likely owns the property, and there's no guarantees against any liens or defects. Very risky. So this is common, like when you go to like the auction, right? And you buy a property at the auction, you can get a great deal at the auction, like at a tax sale or a foreclosure or a sheriff's sale, but and also like you can like if you're a smart investor, you're going to go and look at the property on the county clerk and even the borrower and look at anything you can find against them to kind of help understand what's going on, but still like it might not be the same level of research as an abstract of title from a title company. So that's the risk you take. So I probably own it, but you take it as is, title problems at all. It's a trust. And so a trustee's deed is a foreclosure or a trust transfer. And so this is what we see a lot in Texas with the deed of trust foreclosure. So when I'm going to look at the information on like Guadalupe County, like they basically scan all the trustee sales in and it's onto one PDF file and it scrolls and I just go through it one by one. So like that screenshot I sent you yesterday came right from the county clerk's website. And so if you go back and look at it, it's going to say notice of trustee sale. And so the deed of trust is how collateral is the security instrument for the collateral in the state of Texas. Now, where I came from in South Carolina, they do not recognize deed of trust. They use a mortgage deed. And so the difference between a deed of trust and a mortgage deed is simply that the deed of trust has a third-party trustee And so when there's a default and something called a Liz pendant is filed, and let me know if I'm going too faster and if you're not understanding the terminology because I want to make sure you get it. Okay, that's okay. Tell me, dude. It's fine. I want you to make. I want to make sure you're tracking with me here because this is going to be helpful. Correct. If we were looking in, I don't know if Florida is a deed of trust state or not, but like let's say South Carolina, we wouldn't be using deed of trust. We'd just be using the word mortgage. You're really going to use the same word here. It's really the same thing. The only difference is the security mechanism and how it works. So a deed of trust typically works in a non-judicial state, which means that a foreclosure can happen in Texas without it having to go through an actual lawsuit, like an actual, like doesn't have to go to court. Where in like South Carolina or North Carolina, where they don't have a trustee, where it's just you just have a mortgage deed and then you have a promissory notes that gives the lender the right to foreclose on the property, but it's got to go through a court. Must be. Can you hear me? All good. I'm going to record this and make a YouTube video link, and you can watch it anytime you want, if you find it interesting. But so in Texas, where the most of our work is coming from, Texas does recognize a deed of trust state, and it's also a non-judicial state. So the foreclosure process is much easier and it's much faster than it would be. Like it's much faster than it would be in a place like North or South Carolina or anywhere else they don't recognize a deed of trust. So the only difference between a deed of trust and a mortgage deed is you have a third party trustee that advocates on the lender's behalf, right? They're in favor of the lender. And so when a default occurs, the trustee will be assigned to somebody, another third party trustee that actually enforces the foreclosure. It's pretty much the gist of it, pretty much the way that it goes, and that's the bottom line. So this is what this trustee's deed is, pretty much. So if you buy a house from like a foreclosure auction or a trust liquidation, you're probably going to get a trustee's deed. No, like a deed that was from a foreclosure. So like let's say the property goes to a foreclosure and you like and it does. Yeah, correct. You could get a trustee's deed at the foreclosure. Yeah, in Texas. Uh, limited warranties. Oh, yep, correct. No, the deed of trust doesn't go to anybody. It gets recorded publicly. The seller will get a promissory notes because it's from the. Yes, so that the buyer promises to pay the deed, pay the mortgage. In the event that the buyer defaults and doesn't pay, then the seller can foreclose on the buyer. Correct, and the promissory note. So the deed of so think about it this way. So like the deed of no, it's not a deed. It's not a deed. No, the deed goes to the buyer. Okay, and the deed gets recorded that this buyer is now the owner of the property. That's all that does. It just tells who owns it. Sure. So functionally, like it's called an instrument, right? So like the deed of trust is the document that gets prepared and signed by both the lender and the buyer that communicates the relationship. It communicates no, not no, the deed of trust. So it's back to so you whoever it is. Oh, and a subject to the seller. Yeah, and a sub to the seller is the lender. So technically they're the lender, but their actual mortgage is still the actual lender. So that they have a priority lien. Okay, so kind of yeah. If you want to look at it that way, I wouldn't look at it that way because it's not really a lien. They have what they do have is they have a deed of trust though with the buyer that also gets filed publicly. Okay, so the deed. So think about it this way. So you have collateral, you have deed, okay, and the deed basically shows on public record who owns the collateral, okay. Now, if you can't pay for the collateral with cash and free and clear, then you're going to have to use leverage. You're going to have to use debt, okay, which is where a lender or a bank comes in. Now, the bank is going to secure their money with a deed of trust or a mortgage deed against the collateral. Okay. Now the borrower or the buyer signs a promissory note according to the terms of the deed of trust, promising to pay the debt off. And no, no, it doesn't need to be. You get a copy of that, the borrower gets a copy of that, and the lender keeps a copy of that. No, the promissory note doesn't get recorded. Just the deed of trust and the deed gets recorded. So but no one's give you every deed of trust is going to have a promissory note. Period. It's always going to have one, and so that gets signed at closing. And so what that does is it allows the lender the legal right to go and pursue the collateral or exercising the remedies of a default that are spelled out in detail in the deed of trust. So like if we're going to go and look at the deed of trust online, it's going to show you like who are the parties involved, who's the lender's rights, the borrower's rights, the actual subject property and the collateral, and it's going to go through like all of the terms, like the length of the loan, the amount of the loan, what's a default, what's the cure period, what happens if it doesn't happen. Like it spells it out really, really clearly. And so in the deed of trust, you're going to have all this language that says if the buyer defaulted, does not make repayment, this is the process, this is what we're going to do, this is what we have the right to do. And the promissory notes, what it does is give the lender the right to enforce the measures of the default within the deed of trust. So, like, yes, yeah. So in a subject to situation, they're going to get a deed of trust, and it's going to be similar, like from the seller to the buyer. It's going to be very similar, but they're not going to go and claim and get money back. They're not going to go and sue them. What they're going to do is basically just make sure that it's set up so that they can foreclose. Like if the borrower defaults and does not pay the mortgage that they are in the seller's name, then the seller can go and take the property. Uh, they could, but hopefully that the seller would have the means to stop that from happening. So that's the inherent risk in it, right? There is a risk in it, but like at the end of the day, like it's better than going to the chopping block. I mean, to me, I'd rather sell my house. For me, knowing this, I would want to put a subject to house in. I would want to have the title or the deed held in something called a land trust. And so a land trust, um, they're done for estate planning purposes for the most part, but it makes the foreclosure process in my mind easier. Now, the attorney in San Antonio didn't really like my idea but that's okay. Um, what because so in a land trust you have a grantor, you have a trustee, and then you have a beneficiary. And so the beneficiary is the one who would have the rights to the title. And so to me, in my land trust, I would want to put a performance clause in there when said like, hey, like after X amount of days of non-payment, this is considered a default, then you have X amount of days to cure it. If the cure is not done at this time, then automatically, like without question, the seller or the grantor becomes the beneficiary of the trust again. And so if that, for example, if that happened, if I gave a 15-day default period on my house that I sold subject to in a land trust, okay, and I gave them 45 days to cure it, that would be 2 months of mortgage payments that I would have to make. Right, that's the risk that I take. I would have to make those mortgage payments. Now, if they don't cure that, and if they don't pay it off, right, then what am I going to do? I'm going to go now and have the beneficial interest assigned to me in the way that the land trust is structured. And then now, instead of having to evict them, excuse me, foreclose them, now all I have to do is go and do an eviction if I did it that way. Now that's potentially questionable, and I'm not sure how that would go in a court of law. But to me, I need, like, as a seller, I want to do whatever I can to protect myself, right? And I would have, because I mean, if your buyer is going to be good for it, then they shouldn't matter anyways. You know what I'm saying? So that's basically it. So you have collateral, you have a deed. The deed shows who owns the collateral, the owner that's publicly. Then you have a deed of trust, which secures any investment into any money, any interest in the collateral. And then whoever the borrower is, they sign a promissory note that allows the interested party to exercise whatever rights and remedies they have that are spelled out in the deed of trust in the event of a default. Does that make sense? Okay, so do you understand what collateral is? No, but I want you to understand. So, like, do you understand what the collateral is, or the property? Okay, so we've got that. So the deed, you understand what the deed is? Yeah, the deed communicates ownership. Who owns the collateral? Who owns the property? All right, so if I'm paying cash for that collateral, I'm still on the deed, but there's no deed of trust. Okay, correct. Yeah. So if I don't pay in cash and I use leverage, or I use a bank to fund a all of or part of the purchase of that collateral, that house, that real estate, they're going to secure their investments by me pledging the asset as collateral. Okay, and I'm going to promise to pay them back. And that, yeah, correct. So my promise to pay them back is guaranteed through a promissory notes. Okay, and the instrument or the documents that secures the collateral for the lender is the deed of trust. Uh-huh. Uh-huh. And you sign it. Yes. Yes. Hmm. Yes. Yep. So basically, like, if think about it this way, like the borrower, when they got that loan, used their credits. So think of a sub two as like almost an extension of their credit at that time in history. That's kind of what the play is here. So think about the deed of trust is it's called like think about security. It's security instruments. So the deed of trust and a subject to transaction from the seller to the buyer simply functions. It works as as the instrument or the mechanical way. Yeah, in a way, they become the lender pretty much. If you think, and very simply, yeah. And so if there's a default, then they will be able to enforce a foreclosure spelled out in the terms of the deed of trust that they sign at the closing. Yeah, yeah. So, for example, if you have a second position lien, like let's say I bought a house and I didn't have any cash, but you trusted me, and I got 80% from like a conventional loan, and you gave me the other 20% of your own cash, but I promised to pay you a return. However, we agree to that. Let's say I default on you, and I can't pay you back. And you're nice to me, you're great to me, but you need your money, and 6 months have gone by, and I still haven't paid you back, and so you begin the process of foreclosure as a second position lien, you can commence the process of foreclosure. Now, in a situation like that, the significant like the high likely chance is going to be that the first lien is probably going to try to work with you and make you whole so they don't lose their investment. That's usually what happens, but that's the way that it goes. So that's what we're looking at there. So just the deed though, like we're probably not looking for, it's in our terms and purposes, whether you're looking at, unless you have a private money lender who just doesn't give a rip. Like if you're going to use a hard money loan or you're going to use a conventional loan or a non-qualified loan, which would be like a bank statement loan, they're not, there's any of these deeds you're not going to get a deed of trust with. It's not going to happen. These are going to be cash purchases, and it's because there's not security, there's no title insurance. Like it jeopardizes or puts their collateral at a high level of risk. Does that make sense? Okay. How about you, Daniel? You tracking with me here? You're muted, dude. Man of many words. Okay. You have any questions, comments, concerns? Okay. All right. So as far as us getting lending on a house, like a primary residence, it's going to, or even commercial real estate, like the lender, whoever's pledging capital, they're going to want a general warranty deed or they're going to want a special warranty deed. They're not doing it any other way. So if we're going to go to a like a grant deed, which is not happening in Texas, or a quick claim deed, dude, ain't nobody putting money into that. So that's going to be straight cash every time. So I wouldn't even concern yourself about a deed of trust in this situation. These are just the different kinds of deeds that are available, like depending on the circumstances and how the title is going to be conveyed. So, um, so the trustee's deed is common in foreclosures, trust liquidations, which would be like a bankruptcy, like a Chapter 7 bankruptcy, when like if they're way in their head and they might have to liquidate their assets to be able to pay off their creditors. That's a possibility here too. Um, and a deed in lieu of foreclosure is another one where like let's say for example, I'm in default and I just have no means to make this whole. I have no means to catch up my payments. I have no way to do this. So what I would do is to go to the lender and say, hey, I can't, I just have no way to make you whole. rather than going to the foreclosure, why don't I just give you the deed back instead of a foreclosure? And it's not as bad for me, and it just makes it way easier for you. So like I know it's not ideal, but it is what it is. So basically, it's when the borrower voluntarily gives the property back to the lender. You follow me? And it just gives the transfer the ownership directly back to the lender, and they can go and do what they want with it. But it saves them the time, it saves them the attorney fees, it saves them all that stuff. And so this is still going to go on your credit, but it's not going to be as disastrous as an actual foreclosure is. But it requires a lender approval, and it's usually part of distressed property negotiations. Um, a tax deed, high risk, high reward. So it's issued when a property is sold for unpaid property taxes. So typically, and usually this is going to happen when a property is owned free and clear. Usually. So what will happen is if there's a default on property taxes, this automatically gets taken to this like a primary lien position. So if you owe 200 grand on your house from your mortgage, which generally is a first position lien or a senior lien, and you default in your taxes somehow, if that was possible, if that happened to get that way, then the tax default would take precedence and it would go to first position right away. And if the tax lien is not satisfied, then you'll get a foreclosure for the taxes. Typically, if this happens, your lender will step in and pay the taxes because they don't want to risk their investment. So that's why that house from Colin Kyle, he's $37,000, $31,000 arrear in his escrow. It's probably because for the last couple of years when he hasn't been making his payments, the lender has been paying the taxes and they've been paying and paying for insurance to keep it on. And this guy's just out it. He just doesn't respond to anything. That's probably what's happening there, would be my guess. So the ownership is transferred via the taxing authority, which would be the county tax assessor, and it's going to come with a clouded title. But if you can buy a house that's worth 200 grand for 30 or $40,000, like, dude, you can make a friggin' lot of money with this. Like, you can make a ton of cash. And I know people that this is like their primary and only strategy. However, it's just long. It's a long process because in Texas, I believe it's a 6-month period, or I'll have to look. You can correct me if I'm wrong, but it's either a 6 or a 12-month redemption period. And so what that does, the redemption period gives time for the guy who was foreclosed on to come and rectify the taxes and pay interest on it. And so, like, let's say, so in South, I don't know how, I know it works in South Carolina. So in South Carolina, it's a 12-month redemption period. And so let's say I went to buy a house at the tax sale auction for $50,000 that I believe could be worth $300,000, hypothetically speaking. I went to the tax sale with my own $50,000 in cash and I bought that house. And so for the first 3 months, that 50 grand will collect 3% interest. The second 3 months, it goes to 6% interest. The third 3 months, it goes to 9. And the last 3 months, it goes to 12. After 12 months, if nobody comes along and redeems the property back and they pay the taxes, then now the redemption period is done. So what I'm going to have to go and do is go to an attorney, and they're going to do something called a quiet title action. And what they're going to do is sometimes it could take a couple of weeks, it could take a couple of months, depending on what's going on. But they're going to basically satisfy and clean off all of the liens and encumbrances on that title, if there are any, and make the title marketable. And it will be able to be sold again with a special warranty deed. So in the event that, like, let's say you got your house taken and you owed 50 grand in taxes, and I bought it and I came to 50 grand with the auction, and you came 6 months later to redeem it, you'd have to pay me the $50,000 plus plus all the interest that I've accrued. So you'd probably have to pay me like 70 grand at that point. And if you can do that, then you get the title back. A little bit, yeah. Yeah. So that's kind of the way that it goes. So like that's if I lost the property so you can do really well like this. You just have to wait. So like during that redemption period, I as the owner, the new owner, I could actually go and start the remodel process. But in the event, if I put 50 grand into that house and made it worth a lot of money, and somebody came back and redeemed it, dude, I can't say no. And all that money I just put into there, all that time I just put into there is gone. And they've just gotten a super sweet deal. You know? So that's why you need to wait. So typically, like people that do this, the day after the redemption period ends, they file a suit with an attorney. It costs a couple $1,000 to do a quiet title action, and that's pretty much right there. They're going to need a quiet title action. That's that's going to happen unless they're going to live in it themselves. Then who cares? But if you're going to, it's an investment property, you're going to need a quiet title. So once the quiet title's done, it becomes a special warranty deed from the attorney. You follow me? So those are the basic types of deeds that we will see in our goings and in our doings. Now, next week, I'll have something else that we're going to talk about different kinds of liens on here. So deeds, all it is the document that communicates how title is being transferred and what kind of protections and provisions are there for the buyer and or the seller. The general warranty deed is the best. I mean, you're free and clear, man. You have any problem? Special warranty deed, you're going to be good to go. When you get into some of these other things, you might have to, you really just make sure you're understanding what you're doing, how it's going to work, and what the risk is involved. And if that's something you can swing, something that you can work and you're good with, then by all means, go for it. You have any questions, comments, concerns about this? Is making sense a little bit? What's not making sense? What is not making sense? Okay. So do you understand why Pepper Trail has an issue? They didn't have a will. Yeah, correct. Correct. Yes. Yeah. So basically, the title company needs to make sure that all of these potential interested parties are demonstrably and verifiably relinquishing their interest before they'll be able to say the title's good to go. Well, I'm so like all I'm saying is like if you're going to go on and look at the deed of like go on the county clerk, like these are the terms you're going to see. So I could water them down a little bit, which is fine. But like if you go to look at it and I'm not available, I want to like it's good if you know what you're looking at. Yeah, wait do you listen to Art Katz? That dude, friggin' dude, he's such an eloquent and phenomenal speaker. He's got these phenomenal words. Like he's like, wow, man, like Probably should walk around with a dictionary in my pocket. Just, should probably read some of Abraham Lincoln's speeches and try to, just, yeah. Okay. Let me know if something is not clicking because like it's, mhm. Yeah, they're in that transaction, they're also going to look at you as the borrower as well. But yes, you're correct. Keep going. Yeah, 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 yeah. Yeah, typically, yeah, the borrower is going to, like, for example, like in my house, because Texas is a community property state. So because I'm married, like my wife has to be on the deed. Like she's on the deed. Like so on the loan, I'm the only borrower. So like on the deed of trust, only my name's going to be there. Correct. Yes. Correct. They protect their funds with the deed of trust. Yeah. Correct. Yes. The borrower does. Yep. Yeah, it's going to be notarized and signed by you as the borrower. Yes, correct. And the title company's a notary, so when you're signing the documents, they're going to notarize it all. Boom, 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 boom. They've been through the process. Doesn't mean they know the process because sometimes, hey, sign this. But yeah, you could say that, and that's actually not wrong. Yeah, yeah, yeah. No, correct. Yeah, 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 yeah. Hmm. Correct. They can foreclose. Yes. Correct. Yeah. Yeah. And the loan you're issuing is your own. It's- at that, yeah. 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 Hmm. That's it. So we have a deed that shows who owns it. Okay. Then the deed of trust is the security instrument that secures the investment money against the collateral, against the asset, against the house. Right. Collateral can be like a so like when you look at lending, yeah, car, a boat, yeah, a watch, jewelry. It can be, I mean, whatever, and that's all negotiable. Really, it is. And then and then you have a promissory note, which the borrower promises to pay the lender back. Correct. You can. You can. You can sub to your laptop, dude. I can sub to you my chickens, man. You give me $5 and you can get some eggs for the day. More, and I don't. I only got two chickens right now. But if I had 12 chickens, then we could have that conversation. Yeah. So that's kind of the gist of it. So basic. So just the deed though is what I wanted to focus on. Different ways deeds can be taken, and then so next week we'll talk about different ways title can be clouded or different kind of liens on a property. Your standard one's going to be a mortgage, followed by a tax lien. Yes, I'm actually where I'm giving my claim of interest in this property, and it's going to be signed and notarized. And I'm telling you, like on official record, like yeah. So the quit claim deed could be in Pablo's situation, his right, and I may it could be in Shane's situation too. I don't know because you have a divorce situation or a marriage situation rather than a probate, which the probate is a little bit different because it's intra-family, but it's not like this. It's just a different dynamic. No, they ain't nobody dead in this situation, so I don't want to overspeak and say something I don't know, but yeah, I'm interested to see what the verdict is on this one. But this is the basic function, and so yeah, oh yeah, on both of them. I've had situations. I've had one. You know, it's funny, dude. I was talking to a guy before. The guy that showed me about the land, Jay Mora. I got to talking to him on the phone, and we were talking about a deal that I had under contract in North Carolina one time, and we couldn't get the title cleared. And this dude had to contract him the same property for the same price for the same guy that had a Kansas City freaking Chiefs jersey and a mouthful of chewing tobacco, and he was a very interesting guy, and that we neither one of us could get the title cleared. And so we never could buy the property because if there's somebody that died and we couldn't figure it out, and the title and the attorney was not willing to put the work in, so we weren't able to move that deal. End of the story. Yep. Okay, I'm gonna hit stop on the recording.